and relationship have helped the practice grow consistently and attract high-value corporate clients, multinational entities, and individuals. Our offices are located ALP East Africa and ALP Nigeria. For Africa, by Africa. Africa Law Practice Offices are premier integrated legal and professional services firms born out of the need to provide homegrown and African-oriented solutions. With the global trade and investment opportunities on the rise in Africa, we have positioned ourselves as the trusted partner to provide customized solutions that ensure maximum value creation through the deployment of strategic, innovative, and modern solutions. The ALP team is comprised of a wide range of attorneys whose combined years of experience is as diverse as the African cultures represented within the ALP firms. We are therefore placed to uniquely provide legal advice, knowledge, and representation in the areas of integration and cross-border transactions, energy and natural resources, infrastructure practice, aviation, admiralty, and maritime, legal consulting and knowledge, tax practice, technology, media and telecommunications, business advisory, and regulatory compliance practice, corporate and commercial practice, banking and finance, dispute resolution with an emphasis on arbitration and litigation. Our values of excellence, agility, integrity, and relationship have helped the practice grow consistently and attract high-value corporate clients, multinational entities, and individuals. Our offices are located in major cities of Kampala, Nairobi, Dar es Salaam, and Lagos in Nigeria. You can also reach us via our websites or on social media platforms, Facebook, Twitter, and LinkedIn. At ALP, we are championing and committed to building towards an Africa by Africa. Africa Law Practice, for Africa by Africa.
Ladies and gentlemen, you are most welcome. You're most welcome, ladies and gentlemen. We have many people that are joining the call, and we are very, very excited. Our speakers are already on call, so we are ready to get started. We have our panelists already on call. We're expecting many people that are still joining. This webinar is already being live streamed on the YouTube for the people that could have one or two challenges joining in on the Zoom. But our esteemed panelists are already on call, and we're just going to be introducing them to jump into an exciting discussion this evening. We want to be talking about the state of arbitration in Uganda. And it goes without saying that the people that are practicing, people that are making things happen, that we already have here on call, people such as Mr. Mafabi, people such as Ann Namara, people such as Mr. Philip Alpe, and of course we're expecting and be having Mr. Charles Ouma, the deputy from the Deputy Solicitor General's office. The Deputy Solicitor General himself is going to be on call. Our moderator this evening is a very esteemed person who is not only very passionate about arbitration, but very, very committed to spaces such as this. Ms. Barbara, Commissioner, is also online. So, ladies and gentlemen, it's just my absolute pleasure to invite Ms. Barbara, the Commissioner, Ms. Barbara Kilel, who is going to be taking us away, introducing our panelists, and also being able to kickstart us with our discussion this evening. Ladies and gentlemen, you're most welcome. Share this link, invite someone, give someone a reminder. For the people online, our online etiquette is going to be that you can always post in the chat. You can always post in the chat as the discussions are going on. Our panelists will pick up those questions. Our panelists will also be able to respond to some of those interesting comments that will be coming through. But it's an absolute pleasure. Ms. Barbara is already online, and you are most welcome.
Thank you very much, Laston, and thank you for DSH for hosting us. It's a pleasure always working with the individuals who believe in the same cause, that is that alternative methods of resolving disputes, either through arbitration, mediation, or adjudication, are the most appropriate in resolving disputes globally. And without much ado, do allow me to introduce to you the speakers that we have online today with us. I can happily see Mr. Alika. Mr. Alika and I do have quite a history that began in 2018, discussing or negotiating state investments and state dispute resolution mechanisms for state-funded investment or for parties in investment disputes that affect states as well. So very happy to see you, Alika. I always call him King's Counsel, and he tells me not yet, but I am looking forward to the day when we can refer to him as King's Counsel. So thank you very much. Karibu sana, Mr. Alika. The next up that I can see online is Mr. Michael Mafabi. Michael Mafabi is not a stranger to you if you're a practitioner in ADR, because Mr. Mafabi has been practicing in the field of commercial dispute resolution for quite some time. And he is presently, Mr. Mafabi, if you correct me if I'm wrong, the name of the law firm is SNL, and practicing under the banner within Africa of please remind me, Mr. Mafabi. Seem to forget DLA Piper. Sorry, yes, DLA Piper. Mr. Mafabi is one of the councils, part of the DLA Piper Africa Swiss variant, which is an institution that has various law firms within Africa. So very happy to have you here. He's represented different corporate state entities and clients, foreign investors in very major disputes. I know this because DLA Papa in Kenya with the IKM Associate Advocates has actually supported Kenya win a number of state disputes. So we are very happy to have you here with us. And next online is not least, but definitely our very capable Miss Ann Namara. Miss Ann Namara and I have been part of the Arbitration Women in Africa, and we are looking forward to bringing up the capacity of women in this particular space. And Ms. Namara is quite accomplished as well. She is the founding and managing partner of Namara Musinguzi and Company Advocates, a boutique law firm that actually specializes in arbitration, construction law, and corporate governance. And she's a member of Chartered Institute Arbitration of Uganda and a chairperson of actually the Education and Training Committee. So if you have any questions or concerns about how to be in this space and also become a member of the dispute boards, please make sure you be a friend of Ms. Namara. I am sure she'll be very happy to talk to you about how to be a member of the different dispute boards and also be a member of the Chartered Institute of Arbitrators Uganda chapter, which hopefully will become a branch very soon. We're looking forward to that. And we are looking forward to having this discussion. And once the DSG joins us, that is Mr. Charles Ouma, we will also introduce him. But to kick us off, we'll start with Mr. Mafabi, who can give us a brief overview about arbitration in Uganda and also talk to us a little bit about the different legal reforms that have been going on in arbitration in Uganda, hopefully talk about the policy that has made some changes to the Arbitration Act and how that has affected arbitration in Uganda and how that has also provided an opportunity for the different institutions that manage disputes to prosper in Uganda. So over to you, Mr. Mafabi. Please take us away.
Thank you very much, Barbara, and grateful for that introduction. And many thanks to the organizers, hosts, ALP East Africa, for hosting us. We are grateful for the opportunity to share knowledge. I'm delighted about the topic because it's a timely topic, and I believe that it is at this time, generating a lot of conversation. Now, Barbara, you have asked me to talk about a general overview on legislative framework for arbitration and the general developments around arbitration in Uganda. I want to start by stepping one step back, just going one step back to the early 2000s. Now, prior to 2000, the arbitration framework in Uganda was governed by the old Arbitration Act, which was what we used to refer to as CAP 55. It was a 1964 legislation which was in place, and a number of decisions of the courts which shaped arbitration at the time were decided on the basis of that legislation, including decisions which went up to the highest court of the land. In the year 2000, we began to see several legislative reforms, which included a reform of the arbitration law in Uganda. Effectively, the Arbitration Act of 1964, CAP 55, was repealed in 2000. And the reforms in arbitration followed recommendations of the Commission of Inquiry of Mr. Justice Harold Platt, in which that commission emphasized, as a way of introducing international arbitration into Uganda, it emphasized the need to incorporate international instruments into our arbitration framework and to introduce radical changes and provisions which would give arbitration as a system of private justice the important role that it plays in various jurisdictions. So therefore, the Arbitration and Conciliation Act was ushered in the year 2000, in which new principles based on international best practice world over were introduced. And of course, these principles were characteristics of arbitration as a distinct dispute resolution mechanism. So the Arbitration and Conciliation Act essentially adopted the UNCITRAL model law, which is an international model law adopted by the majority of all modern arbitration legislation world over. So, Barbara, the reforms in the SCA were also influenced by the fact that Uganda at the time had now become a signatory to the Convention on Recognition and Enforcement of Foreign Arbitral Awards, which is commonly referred to as the New York Convention. The New York Convention, of course, as many colleagues will know, is regarded as the cornerstone for international commercial arbitration. And of course, has influenced not just Uganda, but has influenced many other jurisdictions that are state parties to it, and state parties to the model law as we know it. It was an effective instrument because it gave the mechanism for enforcement of foreign arbitral awards to give effect to arbitration as a dispute resolution process. So the reforms were also influenced, and I'll talk about that shortly, by the Convention on Settlement of Investment Disputes between states and nationals of other states, which is commonly referred to as the ICSID Convention. So there was a need in terms of reforming the arbitration law to incorporate international instruments into the arbitration law and framework of Uganda. Now, what then is the status of the Arbitration and Conciliation Act? The Arbitration and Conciliation Act is the primary legislation governing both domestic and international commercial arbitration in Uganda. And we see that in the preamble as it opens, that it is an act which was to amend and provide for domestic and international arbitration, as well as enforcement of foreign arbitral awards, which was a critical issue not covered under the old arbitration framework. So over the last 2 decades, we have seen the growth of arbitration in Uganda. The Arbitration and Conciliation Act used to be Chapter 4, but is now Chapter 5, following the recent, reprints and amendments, reforms to the law. The reforms, of course, were intended to streamline the arbitral process, moving away from what used to be regarded as a complex mechanism, and what was a less straightforward system of arbitration under the old Arbitration Act. So where are we today in terms of the key reforms? It is important to talk about that, because we then begin to assess how these reforms have worked in the growth and development of arbitration, following key international instruments, key international trends, and how that has influenced arbitration in Uganda. And I would just like to start by highlighting some of the key reforms that came with the amendment, because that is important. So number one was, what constitutes an arbitration agreement? We see that in the opening sections. The key reform was that the Arbitration and Conciliation Act was then providing for the formal and substantive requirements for a valid arbitration agreement, so that there is uniform interpretation and clarity on what the arbitration agreement is between the parties when a dispute arises. And of course, in addition to that, establishing what the intention of the parties was when they drew that agreement. So as a key reform, the Arbitration and Conciliation Act sought to provide clarity on that. Number two was clarity, bringing clarity on appointments, arbitral appointments, and constitution and composition of arbitral tribunals. That was a very controversial area, and many colleagues, of course, on the call will recall that there used to be many challenges around the early 2000s based on appointments and compositions of tribunals and allegations against arbitrators, which led at the time to setting aside of many arbitral awards, and of course providing a lot of uncertainty in the arbitral process. It was a very controversial area, but the Arbitration and Conciliation Act, which is now the primary legislation, seeks and provides clarity on how tribunals are appointed. It seeks to provide clarity on the role of appointing authorities, who can appoint arbitrators, It also brings clarity on the grounds and procedures for challenging arbitrators, which was a key reform that was desired under the new framework. We see as a key reform and the establishment of course, a pro-arbitration stance under the Arbitration and Conciliation Act by providing for references to arbitration, where the courts have taken a firm stance on enforcing arbitration agreements to provide clarity, to take away all the uncertainty that was there at the time, of course, with very limited exceptions. But we've seen that, and there's a lot of case law development around that area. We also see one of the biggest developments and reforms to the Act was the extent of the court's intervention in matters concerning arbitration. I think the debate is now won by the fact that the Act is very clear, and the courts have come in to support the provisions of the Act to say there is very minimal or limited intervention by the courts in arbitration. And we see that in Section 9 of the Arbitration and Conciliation Act. A key reform also which was brought by way of clarity under the Arbitration and Conciliation Act was the jurisdiction of arbitral tribunals, a matter that wasn't very, very clear under the old regime. And there was, of course, difficulty in understanding the basis upon which you challenge jurisdiction of an arbitrator and how an arbitrator determines jurisdiction. But with the principles that were borrowed from the model law, we see that it's now clear how you challenge jurisdiction. And the fact that, of course, an arbitrator is the first person, has original jurisdiction to determine their own jurisdiction. A key reform was on due process, and this was intended to legitimize arbitration as a system. There were many questions that were left hanging in the old days about due process and whether arbitration as a method for resolving disputes was a legitimate process. That has been clarified under the Arbitration and Conciliation Act. And the Act also provides for the arbitral procedure, something that didn't exist in the old days. The conduct of arbitrations, party autonomy as to the choices of the rules of procedure and how they want their tribunals constituted, how proceedings should be conducted, very clear under the Act. The Act also introduces decision-making processes of arbitrators, provisions relating to the form of the award, the reasoning of the award, procedural matters concerning corrections of the awards, if there are minor errors which relate to the award. It also provides for challenges to arbitral awards. And this is very, very important because it concerns areas of limited intervention by the court and specific grounds upon which you can challenge an arbitral award. And more importantly, the introduction of the New York Convention under Part 3 of the Act on enforcement of foreign arbitral awards. We also see the enforcement of ICSID awards under Part 4 of the Act. And then, of course, importantly, the conciliation procedure, which is a unique dispute resolution mechanism, now legislated and codified under our Act. But then, of course, a specific section under the same law, which establishes what we used to know as CADA. We still know it as CADA, but it is now a most controversial topic today, and I believe that we will discuss it along the way as we go along in this webinar. The arbitration rules come into the schedule of the Act and provide some sort of clarity. Some have been ruled to be archaic, some of the provisions, but there's essentially some procedural mechanism by which you can either approach the court or deal with a matter and that has been clarified under the Act. Now, Barbara, I wanted to touch very briefly on the question of recent amendments and developments in arbitration as we know them today. Along the way, of course, there were some amendments to the Act, and we saw an amendment in 2008, which resulted from an outcry about CAIDA. CAIDA was the only institution, arbitral institution, that was mandated by law to appoint, as the appointing authority, to appoint arbitrators and do a number of administrative related work to support the arbitral process. That has, of course, been rationalized, the result of rationalization, the impact of rationalization, and the subsequent 2024 amendments have an impact on what CAIDA is today as we know it. It probably certainly means that this amendment falls away, but there were also controversies which resulted from judicial pronouncements about CAIDA. Most of these judicial pronouncements related to governance issues of CAIDA. And we saw in 2018 a High Court judge, many of the colleagues would remember, effectively stripping CAIDA of its power as an appointing authority established under the Act. We also saw the Constitutional Court recently in a petition, a constitutional petition in 2019, making some judicial pronouncements on the constitutionality and nature of decisions taken by CAIDA in its capacity as an appointing authority. Because of time, some of those details may come later, but we've seen development around that, and these decisions have slowly but significantly impacted CAIDA, which was the only institution at the time, which over a decade ago used to be the sole arbitral institution established by law. Now, following, of course, the amendments in 2024, we have now seen that CAIDA has been dissolved into a department of the Ministry of Justice. I'm glad that Charles is on the call. He may probably talk about that. And of course, specific sections under the Arbitration and Conciliation Act, which related to CAIDA, have now been repealed. Now, the debate rages on. Does that mark the end of CAIDA's journey? I don't have the answer. What happens to the existing contracts that were containing CAIDA arbitration clauses? We'll talk more about that. But another key development in institutional arbitration in Uganda was in 2020 when the International Center for Arbitration and Mediation in Kampala, ICAMEC, was ushered in to the private arbitral institution, championed by the Law Society in partnership with private stakeholders to do something about progressing arbitration. And that was established by law under Legal Notice Number 4 of 2020. This instrument essentially established ICAMEC as an appointing authority to support the arbitral process. And ICAMEC, I must say, has made quite significant and positive strides in progressing arbitration in Uganda, with many cases over the last 5 years at least being either administered by ICAMEC as an arbitral institution under its rules, but also a number of significant appointments for arbitrators being made by that institution. It's also a significant role. Its significant role, of course, as I said, is to appoint arbitrators, but they extend towards, depending on what parties agree, administering arbitrations, and of course, they've engaged quite a lot in capacity building and trainings in the arbitration space. And we've seen recently that the institution, ICAMEC, has been endorsed by a number of court judicial pronouncements at the High Court level as a legally established appointing authority. Yesterday, a decision was handed down by the Constitutional Court, where the Constitutional Court declined to entertain a question regarding the constitutionality of appointments made by ICAMEC. We hope that This, of course, will raise the debate as to whether there are any constitutional constraints against institutional arbitration in Uganda. Now, the other point I wanted to make, Barbara, is that the arbitral landscape has also greatly improved and continues to significantly improve with the establishment of the Uganda chapter of the Chartered Institute of Arbitrators, who continue to do significant work in capacity building and advancing arbitration in Uganda. A number of private institutions have also come up to provide ADR services, arbitration-related services. Some of these institutions, of course, have lists of imminent arbitrators from which parties can select, and that's a good thing for the arbitration space in Uganda. Now, all of these efforts speak to progress, in my view, and the fact that Uganda is focused now on a progressive journey towards establishing an attractive domestic and international framework for arbitration. In addition, as I wind up, Barbara, over the last decade, we have seen a lot of pro-arbitration case law developments in support of arbitration, and these have gone a long way in legitimizing arbitration as a private system of justice. And of course, kudos to those who have been players in establishing these. It's a truly remarkable journey and truly remarkable as a country where we are today. I'll pause there for a minute. I think time is fast spent.
Thank you very much, Michael. And at some point, I had thought of muting you, but I think that the insights that you have provided, especially on the legal reform, do give us the basis in which we can continue with the discussion. So I thank you very much for that, especially by starting us off from the very first reforms that began the discussion on how to attract investments in Uganda and to set up a dispute resolution mechanism that is supportive of effective dispute management. So thank you very much, Michael. Please do not leave. We do have follow-up questions for you. And I think for me, some of them are based on the recent English Act reforms on arbitration. And I'm hopeful that we can critique and see whether, given the recent changes to the Arbitration Act of Uganda, if we are honestly going to go back to the drawing table and look at the emerging trends and introduce more reforms to the Arbitration Act in Uganda. But next up, and I'm very happy to introduce him, is the Deputy Solicitor General in the Office of the Attorney General of Uganda, Mr. Charles Ouma. Mr. Charles Ouma is a respected lawyer and very accomplished in matters law. I do welcome him and request that if he is able to turn on his video so that he can talk to us about the effectiveness of arbitration in Uganda by giving us the perspectives of government as a party to arbitration and seeing how government sees arbitration as a beneficial dispute resolution mechanism compared to litigation, especially for government commercial matters. And now in the energy field where Uganda is trying to be the regional hub for energy investment. So over to you, DSG, and thank you very much for joining.
Yes, good evening, everyone.
Good evening.
I don't know whether
We can hear you.
seen. You can hear me.
We can
There
hear
must be
you.
a
We can
problem with
see
my
you. We
video.
have a blank space.
Oh,
Yes.
sorry.
So I don't know whether
Yes,
it is your camera that is blocked, perhaps.
it's possible. But anyway, let me just start off. I think we can rectify the video as we go along. Okay.
Indeed, thank you, and please go
All right.
ahead.
Thank you very much, Barbara. Yes, I'd like to associate with the submission made by Michael, and good evening to everyone who has joined us today. I'm going to speak as a member representing the government, particularly what our perspectives are as a party normally involved in arbitration. and the effectiveness of arbitration in Uganda. Now, government is a very interested party normally in alternative dispute resolution, arbitration being one of the modes, the others being negotiation, mediation, and conciliation. Now, this, like Michael has ably stated, is demonstrated in a number of the laws that have been passed over the years. The Arbitration and Conciliation Act, the Judicature Mediation Rules. It has actually moved also to the tax front, where we have the Tax Procedures Amendment Act 2021, which introduced ADR as a form of dispute resolution. The government, being cognizant of alternative dispute resolution, has gone ahead to pass the national ADR policy, and that was passed by Cabinet on the 10th of February 2025. Now, all of this, in my view, is that there's a deliberate choice of dispute settlement on the part of government, and government is very deliberate in this regard because, being an African country, dispute settlement and the form of dispute settlement is steeped in our nature as human beings, but also our culture. We attempt to look for solutions among our peers. Society, in the most time, is looking for solutions that save on time, solution among peers, and from these peers we get guidance and intervention, which we highly regard. The Justice Needs and Satisfaction Report of 2024 revealed that the majority of people in Uganda rely on the informal justice system, such as direct negotiations, seeking help from family members or friends, and seeking help from local council courts instead of going to the formal courts. Now, arbitration, definitely as a choice by government, is one of those modes of resolution of disputes. And we have got to understand what government is. Government manages society, but is also is the biggest business person in a country. In every country, I bet you government is the biggest business person. It operates on mandates from the people premised on a social contract that is signed with the people on account of a proposal, normally called a manifesto. Ideally, society can reinstate or kick out a government dependent on the deliverables made during a political cycle or term. That means efficiency or effectiveness is key in government work. So whatever government does or engages in, ideally it should be interested in quick turnaround time in matters involving disputes. Of great interest is how it manages domestic disputes, international disputes, and the enforcement of those disputes. So it's in government's best interest to ensure that for, say, a 5-year term, if at all it has an assignment, be it the delivery of a road network or the delivery of supplies, be it water or whatever utilities, that those deliverables are rendered within the time envisaged under the contracts that are signed. These are ideal situations, but definitely there is opportunity for disputes to arise. And these disputes need to be resolved as quickly as possible. As to whether that is actually done is another discourse we can have. But the idea of having contracts where government is a party seized with provisions on arbitration are very key in dispute resolution. Now, someone would ask, But why arbitration? Why not just go slug it out in court? Now, there are definitely benefits of arbitration to government. Based on our very own assessment of the pace at which cases move in a court of law, we notice that it's much slower. We have to line up with every Tom, Dick, and Harry for the resolution of every dispute. I can tell you, after the judiciary conducted its census this year, our very own assessment, because we have also conducted a census in the Attorney General's chambers, we have noted that we contribute about 4% of the cases, a little over 4% of the cases that are right now with the judiciary. It might seem a small number, but you're looking at close to 10,000 cases. Now, if at all we are to line up, especially commercial disputes in the court system, definitely we get bogged down. And that means it affects the delivery of services to the public. Now, the benefits of arbitration I can highlight on the part of government is that they're faster and more flexible. They are cost effective. We can actually budget for how much we may incur when it comes to arbitration. We have greater control over the dispute resolution process, including choice of arbitrators, the rules of procedure, and seat of arbitration. In short, party autonomy. In the resolution of disputes, we are also cognizant that we need to maintain relationships. As government, we feel that arbitration by its nature can afford us opportunity to maintain these relationships with the parties we may be squabbling with. Government is also very interested in confidentiality. In arbitration, confidentiality is maintained, and this is normally very crucial when dealing with sensitive commercial agreements that government may be involved in. We also feel that the enforcement of awards is generally easier. Like Michael indicated, yes, thanks to the New York Convention, 1958, we are party to that. We also have the opportunity to choose arbitrators with specific knowledge and experience in a relevant field. Now, in the kind of businesses government is involved in, you want to make sure that your case, especially a case out of an arbitration, that it goes before persons with specialist ability and experience or knowledge in that particular field that you are dealing with. So it's very important that we are part of this process in choosing who the arbitrator may be, especially if at all we get opportunity to nominate one of the arbitrators. Definitely, the other party will also try to look out for a person with that kind of skill. And in the hope that the two will appoint an umpire with similar or even higher skill to navigate the arbitration process. I've already talked about the benefit of getting out of a court backlog. Definitely, arbitration allows us to get out of that logjam, and that means that the turnaround time be quicker. Arbitration, yes, very good, but I would like to also indicate that in our experience, we have had some limitations of arbitration. It offers limited appeal options. This is one of the issues that we need to address even as we have this conversation. Usually only if there's an error or misconduct by the arbitrator litigation offers more opportunities to challenge a decision. Something that we may need to have a conversation on again with regard to arbitration. Yes, at times we talk about it as being cost effective, but we need to address the issue to do with the higher costs that sometimes obtain in some of these matters. I can clearly tell you in our experience, we have noticed that on account of where the seat of the arbitration is, costs then kick in. Now you will notice that most of the centers are actually in London, Singapore, Hong Kong. In Africa, we have a number of centers, but again, because of some of the parties to contracts, there is a certain aversion to the choice of some of these arbitration centers like Cairo, Kigali, Nairobi, okay, or Lagos. So most of the arbitration centers are out of this continent. And some of these arbitrations involve several parties involved. You may find that as government of Uganda, you may need to get key people within a particular MDA, okay, a ministry, a department or agency. You have got to ferry all these people to London or to Hong Kong or to Singapore. And like I've told you about the distance, that means costs, transport costs, subsistence costs. In certain cases, you have to co-opt counsel from some of these locations, and that means further costs. So those are some of the limitations. Now, I would like to say that overall, arbitration itself is effective. In Uganda, Mike has hinted on something about the developments, especially with regard to CADA. Yes, CADA has been part of the agencies that have been rationalized, and it has been made a department of the Ministry of Justice and Constitutional Affairs. It hasn't yet kick-started work, but following the policy being passed and then also following the review of the structure of the Ministry of Justice, we are fairly good to go with regard to recruitment, so that that center is marshaled by persons with capabilities to start doing exactly what CADA was envisaged to do under the Arbitration and Conciliation Act. There have been a lot of repeals under the Arbitration and Conciliation Act with regards to CADA, but we still believe that CADA shall be functional and shall be efficient and effective. Definitely, this delay has affected a number of dispute resolution mechanisms. A number of contracts had embedded CADA as the appointing authority for the arbitrators. In the interim, what we have been advising disputants is to revise the agreements with regard to arbitration and then opt for ad hoc arrangements so that the disputes are resolved. That has worked out in a couple of cases. There are those who have indeed given up and looked for alternative ways to resolve disputes. So we have engaged in certain mediations, negotiations to resolve some of these disputes. But definitely CADA will take effect. It's regrettable what was experienced with regard to CADA over the years, obviously, which led to a number of court disputes and cases being lodged, which basically put the final nail on CADA, as it were. But it will be restored, it will be fixed, and in collaboration with some of the entities that already exist, we feel that it will be a very good contribution to our country in the arbitration space. And hopefully, with quite some benchmarking and interfaces with other arbitrators, lessons shall be learned to make sure that Kampala becomes an arbitration center too. So thank you very much.
Thank you very much, DSG, and we are grateful for your perspectives in how government, as the biggest business entity, is handling its disputes. And we will now move over to Ms. Namara. Ms. Namara, as I mentioned before, is an arbitrator and actually sits on the boards of different disputes adjudication boards and dispute avoidance boards. And just flowing from the discussions that we've had or listened to the perspective of Mr. Ouma, the DSG, on limited appeal options as being a disadvantage to government when handling matters through arbitration, the question of higher costs, and the issue of the venues that would then seem to be more comfortable to the other parties. Could you tell us, Ms. Namara, from your perspective as an industry player, on how maybe government can avoid costs of arbitration, maybe introducing dispute avoidance panels in their processes or in PPP mechanisms, and show us maybe through giving us real-world examples on how arbitration is the preferred model for dispute resolution. So over to you, Ms. Namara. Thank you very much.
Thank you, Barbara. Thank you, ALP. Good evening once again. And a big thank you to my preceding speakers for setting the tone for this discussion. Michael gave a very good chronology of why the Arbitration and Conciliation Act CAP 4, and which is now CAP 5, was enacted. And its enactment was premised on a report by Justice Harold Platt. And in that report, what they emphasized is that the Act must be in accordance with internationally set standards regarding arbitration. And Michael went ahead to give the different clauses that speak to internationally set standards and norms relating to arbitration. And one of them is contained in Section 9 of the Arbitration and Conciliation Act, now CAP 5, which limits court's intervention to matters only as prescribed by the Act. I know the Deputy Solicitor General has raised concerns about the fact that the appellate process is limited. But to understand why Section 38 is very limiting is to understand the reason for arbitration. And one of the reasons for arbitration, one of the advantages for arbitration is that disputes are resolved quickly. There should be an end to disputes. And that is one of the advantages that arbitration has over litigation. Whereas litigation, you can go up to the highest court. Arbitration is cognizant of preserving business relationships, is cognizant of parties getting solutions very quickly. And in the long run, it ends up being cheaper than litigation because disputes are resolved very quickly. So one of the reasons for that Section 38 limiting appeals to only questions of law and only when agreed upon by the parties is that arbitration by its nature is supposed to ensure that disputes come to an end quickly. I am cognizant of Mr. Ouma's concern that past setting aside under Section 34, if you're dissatisfied, there's nothing you can do. And there I would want to appeal to Mr. Ouma when they're appointing arbitrators, as the courts have told us, that the parties need to choose arbitrators that are competent. So you take your arbitrators, you find them. So the burden is on the parties to ensure that the arbitrators that they choose are competent enough to handle their disputes. And we have so many centers now that can appoint arbitrators. We have the Uganda chapter that appoints contractually. We have ICAMEC that appoints by there being an appointing authority. So what Mr. Ouma is concerned about can be cured when they're appointing the arbitrator. About the success stories, Uganda has been very intentional in following the provisions of the Act, or in standing out or in following best practices of international arbitration, especially limited court intervention. All the way from 2015, we have seen the Supreme Court limiting court intervention. We've seen the Supreme Court in Babcon and Mbale Resort. We've seen the Supreme Court in Rocco and Amid limiting court intervention. Now, in both those cases, the Supreme Court said the Civil Procedure Act does not apply to arbitration. So if you are aggrieved by an arbitral award, your remedy is found in Section 34, which is very limited grounds for setting aside an arbitral award. Only when the parties agree can you go to an appeal. And we upload the Supreme Court for those decisions. However, in the recent past, there have been certain issues, Michael spoke about them, to do with consistency. Because whereas Babcon and Rocco, Hamid said you cannot appeal unless there is leave or unless the parties have agreed. We've seen recent cases where the Court of Appeal seems to suggest that you can appeal when you are aggrieved with a decision. And one of these decisions is the Vantage case. It's a very recent decision, and leave to appeal was granted to the applicant. And now that goes against the spirit of the Arbitration and Conciliation Act and the spirit of arbitration generally, where courts are supposed to ensure that they do not intervene unless as prescribed in the Act. So we're just calling on our courts to be consistent. We're happy with the progress. We're happy with the success stories. We're happy that they have upheld a lot of arbitration awards. They rarely set aside awards, and that's a ground of a safe, that is a characteristic of a safe seat. We are happy that they are following the New York Convention, and they're recognizing and enforcing awards from different seats, with the case in point being Great Lakes, where they partially enforced an award. So we're happy that they are enforcing awards from different seats, but we want to urge them to be consistent and remember the spirit behind the Arbitration and Conciliation Act, which is to ensure that best practices cut across all the arbitration space. So to answer Mr. Ouma, we shall continue to push for limited court intervention because that is a bedrock of arbitration. The doctrine of finality is a bedrock of arbitration, and to cure that, we would urge that you get arbitrators who are competent enough such that the decision is favorable to both the winning party and to the losing party. So our success stories as a country have been that we have endeavored to ensure that arbitration is final and there is limited court intervention, and we call upon our courts to continue with that practice. Thank you, Barbara.
Thank you. And before I let you off, maybe just a little bit on dispute avoidance, if you will, especially as a means of managing disputes for large contracts or contracts that governments are part of. Could you just give us a small brief about what that is and what it entails and its relationship to arbitration?
Thank you, Barbara. For a very long time, arbitration has been seen as a means of dispute resolution, but now we are pushing for dispute avoidance as opposed to dispute resolution. So now we have a process where arbitration is at the tail end. It is no longer the preferred means, because what is preferred now is dispute avoidance altogether. Especially, let me give an example of construction contracts, and especially the FIDIC construction contracts. FIDIC 2017 has recognized how relationships are very important and hence they should be preserved. And they've also seen that arbitration may not go a long way in preserving relationships. So in their general conditions of contract, they have provided for dispute avoidance, meaning that before you start the arbitration process, dispute avoidance and adjudication boards are in place, preferably from the start of a project, to walk the parties through the project and curb any dispute that may arise along the journey. and try and resolve any dispute or try and avoid any dispute that may arise during the journey. How do they do this? They do this through regular meetings, through regular interactions with the parties. They do this through regular documentation, review of documents. So arbitration now has become a remedy of last resort, as opposed to a remedy of first resort, with the remedy of first resort being dispute avoidance. And this is done especially through the dispute avoidance and adjudication boards. So we'd want to urge governments to consider that in their contracts. They may not adopt FIDIC, some may not, but it would be good. It is standard practice in your particular conditions of contract or in your special conditions of contract to advocate or to provide for dispute avoidance boards such that they monitor a project from beginning to the end. Mr. Omar said that arbitration is very expensive. With a dispute avoidance board and an adjudication board, you control the expenses because the disputes are nipped in the bud. So many of them, reports have shown that when such avoidance boards are in place, many of those disputes do not reach arbitration. They are resolved by avoidance. And so we would urge governments to consider providing for adjudication and avoidance boards, but also they can provide for mediation as a way of avoiding the disputes or containing them and ensuring that they are resolved before they become expensive. But the best practice, especially in construction contracts, of which government is a major player, is to provide for dispute avoidance and adjudication boards that walk through with the parties the entire project. They may not be very helpful if they are constituted when a dispute has arisen. They kill the entire aim. So it would be great if they are instituted at the commencement of a project such that any manner of dispute is immediately curbed and nipped in the bud. Thanks, Barbara.
Thank you so much, and thank you for taking us through the dispute avoidance and adjudication processes that can be incorporated in contracts. Now, next in line is Mr. Alika. Mr. Alika, as we keep trying to get him to be King's Counsel, I don't know why, is a chartered arbitrator. Now, for those of you who've just joined us, chartered arbitrator is the highest level you can gain in the Chartered Institute of Arbitrators membership platform. So you have the associate level, then member, then fellow, then chartered arbitrator. And chartered arbitrator is bestowed upon you because your fellow peers have deemed you worthy of being a chartered arbitrator. So welcome very much, Mr. Alika. Mr. Alika will be talking to us about the future of arbitration in Uganda and talking to us especially on what we can do for Uganda to emerge as the preferred destination for dispute settlement. And I know that sounds weird to some people, but it is something that we can do as part of the means of growing Uganda's profile as a regional hub for energy and other businesses. So over to you, Mr. Alika. Karibu sana.
Asante sana, Barbara. Thank you very much indeed for that kind introduction. And my thanks to colleagues, Michael, Charles, and Anne for their contributions. Colleagues, I come to this from a slightly different perspective. And I think it's probably important just to very quickly skate through some of the background. I mean, the vantage point that I have is I spend most of my time sitting as an arbitrator. In fact, I am now almost sitting 100% of my time as an international arbitrator. I currently have 5 ongoing international arbitrations around the world. I also represent our great country in Ancestral, where I make a contribution. I'm not attending all sessions, but I'm certainly monitoring the progress of those sessions. And it's from those 2 vantage points that I am going to offer my views. Michael has said something about, and everybody has said something about the Act. But you know, if one looks, for example, at the Uganda Investment Code 2019 Act, the Act, the first section of first subsection, Section 25, requires parties to consider dispute avoidance. So primarily, the emphasis on the investment legislation is for settlement, if at all possible. The next section, Section 25(2)(a), then actually offers arbitration under the Arbitration and Conciliation Act as an alternative. And it's interesting that, in fact, investors don't go to either of those two sections, it would appear. It would appear, judging from what the Deputy Solicitor General has said, that there is this preference to go for arbitration abroad. And I think that that's absolutely right. I think it's legitimate. And the reason is simply that, in my view, the Arbitration and Conciliation Act is way past its sell-by date. And there are actually things that are fundamentally wrong with the Act. There are reasons as to why it is and was drafted as it was. And I've heard what has been said about Sir Harold Platt's contribution to it. I've also looked at Hansard, and I've seen some of the debates back in 2000 in relation to the Act. But in my view, and this is my conclusion, I think we need a new statute. We need a new statute that more accurately is more faithful to the UNCITRAL model law. The primary complaint that I have about the Arbitration and Conciliation Act is with the role of CADA, which in my view is just quite extraordinary. How CADA managed to survive as long as it did, running arbitrations in Uganda in place of the courts, because it is the courts in every other jurisdiction under the UNCITRAL model law that perform the function that CADA was performing. And I can't really see that taking it in-house into the government makes it any better. Because, of course, investors who are investing, who may well be in dispute with government, the Deputy Solicitor General has told us that the government is a considerable stakeholder in disputes. How is it possible that CADA, as an arm of government, is possibly going to be considered to be fair or impartial in that context? If anything, and this is one of my other conclusions, it should be something that is given to the Chief Justice, that's given to the courts or made part of the commercial court, so that it does really have the independence that it should have. So I've made my criticisms about the Arbitration and Conciliation Act, but I think I need to be able to justify my criticism. And actually, if you look at a number of the sections of the Arbitration and Conciliation Act, you'll see that, and I say this with the greatest respect to Michael, with whom, incidentally, I contribute to the World Arbitration Reporter, the Informer publication on Uganda, that there are problems with the Act. I mean, there are spelling mistakes in the statutes. You know, there's a problem with Section 32, which refers to appointing authority, where it shouldn't refer to appointing authority. There's a problem with Section 17, subsection 2, again, with reference to a center, where it should be referenced to court. There's problems with Section 38, which again has been mentioned by Anne in the context of case stated. There's a reference actually in Rule 5 of the arbitration rules to Section 39. Actually, it was a cross-reference to Section 29 in the Judicature Act, but has now been corrected in the 7th edition. There are problems with Section 34, problems with Section 44(5). And actually, I don't want to spend a lot of time on them, but if you look at each of these sections carefully, you'll see that there's just simply been an incorrect transcription. Now, if we're trying to encourage foreign investors, if we're trying to encourage foreign lawyers to advise their clients that actually it is okay to come to arbitration in Uganda, if they cannot understand what the legislation means because there's some uncertainty in a typographical error. Some of these errors have remained there for over 20 years. We have had the 7th reprint in July of 2024. And that reprint replicates the mistakes that have been there for 24 years. Why is it that we cannot get those corrections in place? We then have an amendment in December of 2024. This was in relation to RAPEX and bringing CADA in-house. I mean, that was another opportunity for us to have a more wide-ranging amendment in relation to the ACA to clear up some of these problems. And actually, colleagues, there's no reason for it not to happen, because I know in 2021, when I read the report, the Uganda Law Reform Commission report on proposed changes to the Arbitration and Conciliation Act, I had identified the problems with the Act, and I wrote to the Uganda Law Reform Commission. I said, look, this is the problem that we've got, let's correct it. Well, you know, my advice has not been heeded. Nobody's read it. It's certainly not been incorporated. And it's unfortunate. It's unfortunate that colleagues who are involved in arbitration in Uganda are not consulted as widely. I know there was a practice, certainly under the previous Attorney General, where proposed amendments and proposed legislation was sent out to the Law Society for input and contributions. I mean, if that could or had been done in relation to this most recent legislation, then it would have been an opportunity for us to help. So, in a nutshell, we say the law is out of date. We need to try to make a more joined up and cohesive approach to the legislation and amendments to the legislation. The third point I wanted to make is that in relation to what we should do, I think we should start again. That means just sitting down and rewriting our legislation. I mean, in my view, England has the best arbitration act. And it's no coincidence that the states of Abu Dhabi, DIFC, Mauritius, are similar because they were written and or influenced by the same leading council. You've got really good legislation in Nigeria. You've got good legislation in Ghana. I mean, Tanzania, as I say, or I may not have said, has followed the English Arbitration Act. But, you know, there's no point and no need to reinvent the wheel. If we're talking about putting ourselves on the international stage, then we should do it. You know, there's no point in buying the plans to build a Mercedes when you can go and buy a Mercedes or whatever it is that you think is the best. I mean, there's no need to reinvent the wheel. So what else I think we need to be concerned about is regulation in arbitration. The Uganda Law Reform Commission report was concerned about arbitration, was concerned about corruption in arbitration. By the way, you know, corruption, people say, oh yes, well, you know, we have a big problem of corruption in less developed countries, but that's not actually true. And I know from first-hand experience sitting in UNCITRAL that we, Uganda, raised the question of codes of conduct. And this was codes of conduct that would affect judges and also neutrals. And actually, it was raised by me personally in the context of my having suffered from having one of my awards set aside in a judgment that was literally a copy and paste of the award debtor's documents. Typographical errors, spelling mistakes, words unknown to the English language, which were just taken from those documents and replicated in the judgment. I mean, the judge should not be very pleased with the judgment, but in any case, it was signed. But it was as a result of that we raised the question of corruption in the hope that the United Nations would take up the cause and do something about it. It was very interesting to see that our plea found favor with a number of states. In fact, indeed, all states in the end, but Mexico, Chile, Japan. So this problem is not a problem that is limited to one part of the world. It's a universal problem. But my view is that we need to have, as part of the Act, and I think this is one of the good parts of the Arbitration and Conciliation Act, it's the attempt to actually regulate the practice of arbitration and the licensing and the qualifications, because I don't think we're at a stage yet where that can be left to self-regulation. I think the problem has become so bad. And indeed, I know from Kenya, where there are real concerns about integrity in arbitration, there is talk of seeking to actually impose regulations. In terms of a blueprint for that, the problem also, by the way, has been in England. And what the LCIA did in the last rules was they introduced an annex to the rules, which actually now has a code of conduct for counsel. So any counsel who's misbehaving may be found in breach of the rules, and that ultimately could find its way to the Bar Council and could end up as a disciplinary issue. So, you know, there are a number of aspects that we need to look at in terms of regulation. I just want to deal with, finally, the proposals for change. I think it's important to understand that you have to look at arbitration and the infrastructure of arbitration almost as a continuum or as a hierarchy. So you'll have national laws, you'll have perhaps soft laws, or regulations, soft laws, and guidelines. And we need to think really carefully about how we draft our legislation and how the rules and the soft law interacts with those rules. Take, for example, ICAMEC rules, which are pretty good rules as rules go, which fill in many of the blanks that are left in the legislation. Some of the gaps that are left in the ACA are dealt with very well, actually, in my view, in ICAMEC. So that's something we need to think carefully about. And on that basis, I'll just say that the working group 3 at the moment, which is the UNCITRAL Parliament, if you like, forum for discussion, is looking at limitation on the amount of evidence as a way of driving down costs and time, limits on document disclosure, greater powers on the arbitrators to limit late evidence being adduced, whether or not a greater discretion to rely on witness statements. In other words, there may be the option of actually opting just to read witness statements rather than having live evidence. There's a possibility of excluding evidence. There's possibility of bifurcation, greater use of bifurcation. There's interim and provisional measures, and the tribunal itself having the initiative to impose interim measures rather than leaving it to one or the other parties. You've got greater use of security for costs, to try and ensure that one party is not left out of pocket. The Attorney General in Uganda has rightly complained about people raising unmeritorious, hopeless arguments just for the sake of driving up costs. The discussion at the moment is about trying to give the arbitrators the right to simply say, this is a hopeless point. If you think it's got legs, let's have a preliminary hearing. Let's determine whether it has got legs. And if it doesn't, you pay the costs of having this argument. So really dealing with things much more decisively, dealing with frivolous cases. There's also the question of security for the claim. Usually, of course, when you bring a claim, you're not allowed to get security for the claim. But LCIA rules, Singapore rules allow arbitrators to award security for the claim. So again, an unmeritorious claim, somebody is holding your money, you can say, actually, I want that respondent to give security for the claim. They have to pay the money into court, again, with a view to putting pressure on parties. Issues on third-party funding, the requirements to disclose third-party funding, the implications for costs of third-party funding, whether or not third-party funders should be entitled to their costs. I mean, you can imagine if a third-party funder is funding a big litigation or a big arbitration with a view to getting a cut of the damages, many of them will just keep paying and funding and funding and funding, because actually for them it's a gamble. And the longer that they can get this going, they can, it might become a war of attrition, and they might end up getting some kind of settlement. So that's important too. There's a power to suspend proceedings in circumstances where there are negotiations. So you don't have people playing this game where they're trying to negotiate and at the same time putting pressure on the states to fight on. Time limits for awards proposals, 60 days. 180 days, 240 days. I personally have a view that 60 days is too late. I think we have that in the ACA under Section 31. It's just too short a period of time, but it is something that one can think about. In the context of investor state, which is different from conventional commercial arbitration, there's also talk about allowing states to counterclaim, because of course you're before the same tribunal. The counterclaim may well arise out of the same or substantially the same facts, and states should be allowed to counterclaim. There are questions of joinder, giving arbitrators the right to join and consolidate proceedings if they arise out of the same circumstances. And actually, colleagues, the list goes on and on. I could spend quite a long time discussing that. But I'll very quickly just say what may need to go into rules, but not into the Act. Things like virtual arbitrations for virtual proceedings, expedited arbitrations, emergency arbitrations, summary judgment. Summary judgment in the new English Act has been introduced. So again, in the old days, arbitrators were afraid of summarily determining a case because the other party would argue that it hadn't been heard. And that's one of the principal pillars of arbitration. Now the arbitrators under the new English legislation can simply say this is a hopeless case. So you see how the English transformation amendment is also being reflected in ISDS. So that's the way the world is going. There are questions of arbitrator immunity, codes of conduct. There's this question of applicable law, which we can raise in the discussion. Just two other points, I think, which are really important. As we think about the Africa Continental Free Trade Agreement, and as we think about integration and cross-border trade and people using their mobile phones to buy things from Kenya, from Tanzania, from Rwanda, and this international, we have to think about the prorogation of jurisdiction. We've already had this problem in the Ham case and banking and whether or not you've got cross-border banking. But we need to have some infrastructure, some rules of court that deal with the allocation of jurisdiction as between the different African countries. I mean, if a Tanzanian is buying something from Kenya and a dispute arises and both parties go to their respective courts and issue proceedings, which court has precedence? In Europe, it's been resolved by the Brussels recast. In the United States, it's dealt with in one way. In federal republics like Nigeria and in the UAE, it's dealt with another way. We also start having to think about effectively rules that regulate a quasi-federation. And finally, there's the question that the Deputy Solicitor General raised about appeals. I'm going to suggest maybe the Multilateral Investment Court may be something that we can think about in terms of, you know, if we're going to introduce an appeal process to have it go to a Multilateral Investment Court, on which we would have African appointees and perhaps even a Ugandan appointee to give us the satisfaction that it is something that it involves us, that we can buy into, and that reflects our views. Ladies and gentlemen, there's a lot to say, but I hope that's been a start to the conversation. Thank you very much.
Thank you very much, Philip, for your comments and your insights. We really appreciate them. But just before I let you off, and maybe just to start you with the questions that we have received. DSG mentioned the question of confidentiality and the need to promote confidentiality in government matters in arbitration. But we know, especially for ISDS matters, there has been a call for transparency of disputes that involve government as a party because of the question of public funds. Maybe you could just share with us a couple of insights on that. And the last issue that has been raised is on the International Bar Association Code of Conduct and how that will be useful, especially in promoting integrity in arbitration matters.
Yeah. So I'm just starting with the second one. I'm not sure that I'm familiar with the IBA Code of Conduct.
Not the code of conduct, the standards and guidelines for arbitrators and counsel and third party.
Party representation. Yeah, okay. So no, I think that thank you, Barbara, for those two questions. I mean the IBA guidelines, like all the other guidelines, and there are a superfluity of them, and we sometimes get the names confused, but they do provide a really good guide as to how one should conduct oneself and the situations in which one may become professionally embarrassed, the circumstances in which one should consider what they should say to an arbitrator. And I don't want to say much more than they reflect a collection of views of many practitioners from different traditions that have formulated these principles, and they are a really good guide that one should really look at and try and abide by. So that's what I say on party representation. I will, during when I come off screen, just look for my copy, and it may well be that I want to supplement what I have to say on party representation. On the question of confidentiality, I mean, this is the great chestnut. This is the really difficult problem that states, and indeed state entities, and sometimes even parties, have want to have and preserve confidentiality in the arbitral process. And if you were fortunate enough to hear the speech talk this year that was given by Dr. Emilia Onyema for the Chartered Institute on this conundrum, because you see, as the Deputy Chief Justice was saying, I mean, we as citizens are interested parties. If the government is building a road network, or it's building a dam, or it's got a commitment to provide electricity, that affects us. And if there's a delay on any of those projects, it affects GDP, it affects our businesses, and so on and so forth. And it's ironic that although we are actually the clients, we don't get to know what is being said in our name. And there is a view that really there should be transparency. There should be transparency as a matter of, it should be routine. We shouldn't have to be left wondering what it is that our government is arguing, or the positions it's taking in our name. But I think it is something that at the moment has been left to the states. I mean, if you look at the UNCITRAL rules and the amendment in 2013, this is the Mauritius Convention on transparency, you'll see that it's being left pretty much to the parties on a case-by-case basis. A consensus could not be reached in the UNCITRAL as to which way to go. But the pressure is increasing. The pressure is increasing, and I think there will come a point in time in the not too distant future when the clamor to ensure that all arbitrations involving states are public. And I think when one state breaks, it's going to be very difficult for other states to resist making those arbitrations public. And I understand the Deputy Solicitor General says that these are commercial and confidential. Well, they're commercial, but they're confidential, but they belong to us. They don't belong to the state. We are the state. That's what the Constitution says.
Thank you, Philip. Thank you, Philip. And please, for the participants, if you are online and you would like to ask your question live, please raise your hand. We only have 8 minutes left in this particular webinar before we close off. But the questions that I have received, DSG, if you're still with us, and Mr. Mafabi, any one of you could take this question. The question is actually on the issue that had been raised by Philip on the inconsistencies in the Arbitration Act, and to hear from your perspective, especially DSG, on whether there will be further reforms on the Arbitration Act to address those, and if so, what would be the way forward, especially given the comments made by Philip on the role of CADA going forward, and what would be the timelines, especially of setting up the department and making sure that they are seen to be transparent and accountable in the way that they do the appointments of arbitrators or in the administration of disputes. Would the CADA rules still be applicable, or would parties be required to come up with their own rules? So over to you, DSG. And Michael, I see DSG has unmuted, so please, over to you, DSG.
Thank you, Barbara, and thank you very much, Philip, for quite an extensive. I know time is not our best ally. You would have had much more to say about this. But let's make good use of whatever you have posted. Now, to address a couple of issues, let's start with CADA being rationalized and being made a department. Of course, RAPEX was the buzzword. I can say I've only been in the office for 9 months, but also from the outside looking in, I had issues like most of you may have raised. What I've noticed since coming in here is that the focus was deal with the rationalization and then maybe deal with other issues that accompany this rationalization in due time. What I would like to draw an analogy to is, for instance, you have the Uganda Registration Services Bureau, you have the Administrator General. All these are departments under the Ministry of Justice and Constitutional Affairs. Save for maybe the Administrator General, who is a corporation sole and has the capacity to sue and be sued, similar to URSB. What definitely is a shift in this, in the Arbitration and Conciliation Amendment Act is that CADA was made a department. The hope, and this is something that I engaged the Attorney General on, was that it would be allowed to be as independent as possible and exercise the functions under Section 68 of the Arbitration and Conciliation Act, but also make sure that it does regulatory work. However, just because there has been this amendment and focus on rationalization doesn't deter further amendments to the Act. And I think we're at an inflection point that there's need for a review of the Arbitration and Conciliation Act in totality. What I'd like to encourage each and every one of us here, particularly the cluster within the law society that is involved in arbitration, that you could prepare a paper. And Philip, sorry for what might have happened with regard to the Law Reform Commission. They may actually be en route to join us in the Ministry of Justice and Constitutional Affairs if their rationalization also takes place. But we would definitely welcome a paper or in a presentation on what the possible changes can be. Okay, what can be made to make this particular law more efficient, more effective, but also more investor friendly. At the end of the day, any investor would want to make sure that even when they put their money into this country, that there is an assurance that in the event that there's any dispute, they have a forum to go to where they will be heard without any machinations on the part of government or any other entity, and that they will get a result which wouldn't be any different from, say, in Singapore, Hong Kong, or London. Yeah. So for me, that is an encouragement that I'd like to make to the team. We could still work together, formulate something, and have a conversation, because for me, this is more of a, how do we make this country business friendly? How do we make this country responsive to society generally? Yeah. With regards to the question of confidentiality, I totally agree with you on one side with regard to being open. The state definitely represents the people. But maybe the reason why there hasn't been harmony with regards to opening up on matters to do with state affairs, a lot of it has got to do with geopolitics. It has got to do with how states manage affairs. There are certain secrets, and you can also notice that in certain companies, there's always protection of information, which if it went out or got out there, would have an impact on their corporate bottom lines. Now, even as a country, the greatest concern is what the rest of the world out there may get to know about the operations of a particular country. It's a conversation that is still up in the air. The question is, we may need to have some kind of self-introspection as countries. To what extent can we be transparent? Are we public limited companies that have to put out our wares out there for the whole world to do an assessment? If we drew that analogy on account of the social contract that people enter into with government, then may be true. The question is at what risk? And we have got to do a thorough analysis of this. It may be a case where we create exceptions. It shouldn't, in my view, be 100% open out there. After all, arbitrations by their nature are intended to be confidential. But what is it that, as a government, as a party, what is it that you can put out there for the whole world to get to have a look at or get to know? Or should it be restricted to only your citizenry? So this is a conversation which for me can still go on, but it's legitimate. But let's also look at the flip side to it. Thank you very much.
Thank you very much, DSG. I don't know whether, Michael, you have 1 minute input into that, or we can go into your closing statements as we chat. And if you allow me, because I've seen you've unmuted, meaning you do have feedback. There is a question on, and I'm hoping Anne can take this, on how to get to be a chartered arbitrator. Then the second question, Mafabi, when you're giving your input, maybe you can advise a law student who's considering a career in arbitration. How do they address it? Then finally, we'll have the comments from the DSG. There's a question here to you. The question is, I don't know. So let me just read it out as it has been placed. There is a word that government now prefers litigation to arbitration in dispute resolution clauses while contracting. If this is true, doesn't this undermine the growth of arbitration in Uganda, given that government is the largest commercial entity at the moment in Uganda? So, Michael, have your input and last feedback. Please keep it to 2 minutes. Then we'll move over to Anne for your last comments and the response. Please keep it to 2 minutes, and the DSG, and finally Alika. And then I will wrap up and tell you about the next webinar that's upcoming. So over to you, Michael.
Thank you very much, Barbara, and thanks to all colleagues who have contributed, the DSG and Philip. I think just adding on to what the DSG has said, I mean, the government has spoken, there's very little to add. I think in terms of introspection and reflecting on what Philip has said, it is fair to say that there are certainly inconsistencies in the SCA, and I think Philip and I have expressed those views in our contribution to the World Arbitration Reporter. Whether or not the Act needs a complete overhaul, I think is a different debate altogether. The truth of the matter is that there's need for very serious reforms and amendments to the Act. But I would like to also say that maybe, 24 years is a very long time. It's been a journey. I think that we are somewhere. We're working with what we have, and I believe that there's been a lot of good faith and goodwill from stakeholders who have participated in the progress of arbitration in Uganda. So I suppose, as a DSG did say, it is time to look at the reforms, to look at the Act again, and I would suppose maybe we don't need to reinvent the wheel, because I mean, Philip has contributed to the Law Reform Commission and suggested changes. A lot of colleagues have done so. Judges have said so. So there is a starting point for us to begin discussing and debating issues that require, amendments. Now, to the next question, Barbara, on I think a law student considering a career in arbitration. I think it's now easier than it was in the old days because there are templates to work with, and there are now mentors available. I always say that the starting point for a law student is to identify, first of all, where their interests lie. And if the interests lie in a career in arbitration, it's good to begin early in identifying, mentors who can mentor you in this new field, which is a growing field in arbitration, so that, people can walk the journey with you and guide you on where to look, either for resources on arbitration or research, but also generally to play an active role with social media now today. There's a lot that can be said if you are a law student aspiring to pursue a career in arbitration. You could start by posting thoughts on what you think about arbitration, or putting together thoughts around what you consider to be the best way forward in terms of progressing arbitration. Those are eye-catching, and people always listen to those or read those, and you can be encouraged from that perspective. That's my thought, Barbara, and I would like to thank you for effectively moderating us, and to thank the ALP East Africa. My parting shot is that it's a journey. It's been a long journey. A journey of 1,000 miles begins with one step, and we are there. We are progressing, and we will get there. It's not perfect, but we'll get there.
Thank you very much, Michael. Over to you, Anne, for your parting shot and answer to the final questions. And maybe just to add, Anne, if you could tell us a little bit about FIDIC. I know you mentioned it, but for those that do not have an interaction with FIDIC, this is the International Federation of Consulting Engineers who have developed standard forms of contracts for construction. So, Anne, maybe you could just tell us about the different books, what they do, and the question that was posed to you and your parting shot. So over to you, Anne.
Well, thank you, Barbara, and thank you, ALP. Thank you, Philip, once again, and Michael. The pathway to becoming a chartered arbitrator in Uganda. The Chartered Institute of Arbitrators Worldwide is the platinum standard for arbitration practice worldwide. When you have a qualification of CIAB, you're considered to be in a different league as an arbitrator, certified. So when you say you want to become a chartered arbitrator, that is the pinnacle in the different stages of membership of CIAB. So the first stage is applying for associate, and then you move up the ladder to member, to fellow, and then to chartered arbitrator like Philip is. So CIAB operates through branches and chapters, and in Uganda we're privileged to have a chapter. Barbara keeps saying that we're about to become a branch. Very, very soon we're about to become a branch. So CIAB Uganda conducts pathway events, pathway trainings. Please follow CIAB Uganda social media for the dates on when those trainings shall be conducted. And the pathway is to start with the associate level or membership level if you have some knowledge in arbitration. So that is the pathway. You start with associate, and then the ultimate is a chartered arbitrator. Barbara asked me to speak about FIDIC. I'm not sure where to start from, but let me try and compress it because it's very wide. So FIDIC she explained what it is, and it is a preferred form of contract in construction projects for especially MDBs and World Bank and other funders, international funders. So it operates through books, what we call the Rainbow Suite, because there are different colors depending on the risk. There's the yellow book, there's the red book, there's the silver book, there's the white book, there's the green book, and time is really limited to explain what all the books are about. But what I can say is that FIDIC is a preferred form of construction contract because it ably allocates risk to the party that is best placed to bear the risk. For example, in the red book, where the employer is in charge of designing the whole project, he will bear the design risk. It cannot be passed on to the contractor. The reverse is true in the yellow book, where the risk of design majorly lies with the contractor, that the employer will have less risk there. We have the silver book that is known as the turnkey. Here, the contractor is in charge of the entire project, and he only hands it over at the turn of a key. That's why it's called turnkey, such that the employer at the turn of the key is able to take charge of the project. The white book is used for consultancies, especially consultancies and The Green Book is used for medium projects that are not very big, projects of a very small scale value. But I would encourage us all to study more. Follow FIDIC, they have different courses. Locally, we have Construction Law Institute. Please follow it. It has courses that it offers, foundational courses of FIDIC and all the other types of contracts, SNAKE, PPDA. Follow them on X, follow them on LinkedIn, follow them on their website, constructionlawinstitute.com, and become a certified, start your journey on becoming a certified FIDIC practitioner. My parting shots. First of all, I know the question is not addressed to me, but I would like to my parting shots are twofold. One, to government. There's a question that there is a concern that government prefers litigation to arbitration. And this is something I said before to Mr. Ouma. Other than throwing out the baby with the bathwater, let us work together. If it's about expense, we can talk about dispute avoidance. We can speak about how to make Uganda a preferred seat and venue, such that there are no costs incurred in traveling to London and Singapore and all these other places, but also a preferred seat. A preferred seat starts with our courts being consistent in their decision. A preferred seat starts with our courts embracing finality of arbitration and limited court intervention. We may not be able to achieve a preferred seat if our courts are here and there about their decisions. We request that the court system is strong. We request that the court system is 100% pro-arbitration. And then about people who are skilled, like we mentioned, there is the Uganda chapter certifies. There you will have a chance of getting arbitrators who are certified. ICAMEC also certifies. And so I propose that government works with these centers to get certified and skilled arbitrators. My parting shots, we've discussed so many things today. We've discussed the need for DABs, we've discussed the need for amendments to the Act, we've discussed the need for consistency, we've discussed the need to make a safe seat, to make Uganda a safe seat and a preferred seat. And I would like to invite us all to begin to continue with this discussion in the first ever International Arbitration Conference organized by CIAB Uganda chapter that is scheduled for 13th to 14th November at Mestil. Details are on our social media handles. Please come and we continue this discussion with people from around the world. Come and network, come and air your concerns, come and get different perspectives because it's international and we're expecting different delegates who shall give different nuances on arbitration. So please register and please be part of it. Thank you, ALP. ALP is home and I'm glad to be back home. Thank you very much, Barbara, for excellently moderating and have a good evening.
Thank you very much, Anne, and thank you for your parting shot. Indeed, we are looking forward to the Chartered Institute of Arbitrators Uganda Chapters Conference in November, and we do hope to see everyone there. So parting shots from DSG and your feedback on the comment on government's appetite for having their matters resolved through arbitration vis-a-vis litigation.
Yes, thank you very much. I think Anne has hit the nail on the head. I normally prefer thinking like a scientist, diagnosing the problem and getting the solution. Actually, when I joined the ministry, one of the things I noted is that there was a combination of the use of litigation and also arbitration in certain cases in contracts, dependent upon the circumstances. But definitely when I asked the question about why litigation was chosen in certain cases, again, it was about austerity measures, trying to reduce on the cost that arbitration would accrue with regard to dispute resolution. But in my view, definitely, we encourage arbitration. We have currently over 70 cases where we're involved in arbitration. It's not something lost on us that it's effective, but we definitely have got to diagnose the problem as to why the choice of litigation was made in the past. Obviously, after government passed the ADR policy, you will notice in that policy there has been an encouragement to use alternative dispute resolution, including arbitration. And we welcome arbitration as a mode to be used in dispute resolution. Definitely, like I told you again, we do not want to choke your typical traditional court system with some of these cases. And I've rationalized why we would rather choose arbitration, especially for these commercial cases. So it is something that we are working on internally here to redress, but it's a fact, and it's something I also found when I joined the ministry, that there was a combination of both arbitration and litigation, again, dependent on the circumstances. So that is something we'll endeavor to sort out. Now, just some parting shots to especially the students who and the young lawyers who may be very interested in this area. You know, Michael has hinted on some of the things that should interest you in this area. I'm going to talk a bit about best practices, and just allow me just 1 minute to run through them so that people understand why arbitration is necessary, but also the best way to secure an outcome for you as a practitioner. Like Anne stated, we have got to always focus on avoidance, and that means we have got to start with the arbitration agreement. From the moment you draw that agreement, you've got to have some kind of giraffe eye and view as to the potential of what may come out. So the way the arbitration agreement is drafted is very key in how you potentially resolve your dispute. So understand the dispute and develop your case theory. Organize and present your evidence effectively. Choose your witnesses with care, both factual and the experts. Definitely draft a persuasive statement of claim and develop a theory that you want to present to any arbitral tribunal. Key here is understand the costs and timelines and budget accordingly, even as you prepare for any arbitration. Select the right arbitrator, those with expertise and experience. It's very important that you choose those. Investigate the facts of the matter thoroughly. Discover whatever documents or evidence that you intend to tender, and stick to the theme of your case. In my view, these are best practices in securing the best outcome whenever you're engaged in arbitration. This is an area that is gaining some traction. I would like to invite the members, especially the young lawyers, consider this an area of interest. This country can only grow, inshallah. All right. And we pray that progress is made. Thank you very much. Thank you to ALP and the team for organizing this. I would again like to reiterate to the team in the arbitration cluster, please engage us. If need be, schedule an appointment. We can have a conversation about all of this as the Minister of Justice and Constitutional Affairs. We have a whole department of arbitration here. Let's have these communication channels open. Thank you very much.
Thank you very much, Bona DSG, and for the guidance provided, especially to the young counsels that are present. And one thing that I think we have not added is that they do not need to be lawyers to be arbitrators. So that is open for different professionals to come on board. So over to you, Philip, for your final parting shots before we close.
Thank you very much indeed, Barbara, for that. I know I'm standing between people and their evening meal. I mean, it's been a pleasure to be here. I'm really encouraged to know that there are younger members of the profession, colleagues who are on this webinar to learn. If I may just take a slightly different approach from the Deputy Solicitor General by saying that I think if you really are also thinking of building a practice, you need to think strategically about your work. you must remember that the opportunities, well, first of all, you have to be competent, which means you really have to be technically competent, which means you have to know the law and you have to know the arbitration landscape. There's no substitute for that. But beyond that, there's relationships and professional associations that you have to build and foster. Nobody can succeed on their own. You have to succeed with other people, and you do that by working with people and demonstrating to people your competence and your ability. And sometimes that means somebody who you appoint as an arbitrator or somebody that you're against. All these things come together to coalesce to support you and help to propel you on your way. Don't just look in Uganda. Look in Kenya. Look further afield. Look internationally, because we're all related. We're all one. I always say to people when I mentor them, if you're going on holiday somewhere, put a suit in your bag and call up a lawyer who's doing arbitration and say, I'm here, I'm visiting from Kampala or wherever you're visiting from. Make a friend and see how you go. Rome wasn't built in a day. Kampala wasn't built in a day. As Michael says, we're on a journey. I just want to say one good thing about the Arbitration and Conciliation Act, which is Section 59, which is the section that provides for settlement agreements to rank as arbitral awards. Actually, that in a form is what the Singapore Convention did. And the Singapore Convention, of course, was agreed in 2019, and that provides for settlement agreements to effectively have this passporting effect. Uganda was way ahead of the rest of the world on that one. So, there are some really good things about the act, and I agree with Michael. It's not all bad, but we are Ugandans, and it could be perfect. And I know we're capable of perfection. And so, sorry, but that's my view. So, colleagues, I think we're all in this together. We all want to do well, and let's do this together. Thank you very much indeed, and thank you to ALP. Thank you to everybody for being so patient, and thank you for your attention. Thank you, Barbara.
Thank you very much, Philip. Thank you to all the speakers. We have been greatly enlightened by your presentations. And participants, just to let you know, on 18th of September, given the the current African Nation Championships that are going on, we do want to invite you to the webinar on sports and dispute resolutions in sport matters. So please stay tuned and keep following the Dispute Settlement Hub social media handles for that. And just to conclude us and to get us to a close, there are 3 key issues that we have noted from this. And I hope that the Dispute Settlement Hub will continue pushing through, is the paper that has been requested by the DSG on the reforms that are needed on the Arbitration and Conciliation Act. And I'm hopeful that this will cover all other legislations that do inform arbitration in Uganda and can promote Uganda's role in the region as being the preferred destination for dispute resolution. The second one is to the DSG, the future of CADA. It would be useful to get guidelines from the Attorney General's office or from the Ministry of Justice and Constitutional Affairs on the structure that CADA is now going to take, a transition plan for those who have matters, who have contracts that have included CADA as the appointing authority, so that there is certainty in how arbitration will proceed. And finally, a call to all of us to include and incorporate dispute avoidance in dispute settlement clauses so that we are able to manage disputes effectively and efficiently. Once again, thank you very much for joining us and for spending time with us. We appreciate you all, and we appreciate the DSH Settlement Hub for hosting us. And have a good evening and see you next time. Thank you and good night.
Thank you very much. Have a good night.
Thank you very much.
Thank you. A good night to you.
Thank you. Night.